You end up using the microphone in YouTube.
Thank you. It's loading. Thank you, Shane.
Yeah.
Stop. It is muted. Perfect. Okay,
Go ahead, Chris.
think so.
Okay. This is the special meeting of the zoning board of appeals, Tuesday, March 11, 2025. And we have the roll.
Brown, Hendricks,
Here.
Marshall, Stein.
Here.
Okay, we will start with public comment. Does anyone have any public comment? Address.
Yes, please.
Lori Paul, 603 East Lake Street. And my comments tonight regard the construction of 500 Rose Street on the corner of Division and Rose, where the historic house burned down. The zoning variance was granted to the property in June of 2023 by the Zoning Board of Appeals. I was chair at the time. The applicant's specific request was to reconstruct the home garage porch. A sample motion prepared by staff included a height variance of 8 feet and a rear yard setback of blank feet to accommodate the request. The minutes accurately reflect a robust discussion with the applicant regarding height of the proposed construction and his intent. The applicant himself said, quote, "Their intent was to rebuild it as it once was. They have no intention to build it any higher," unquote. This was supported by a series of photos of the house submitted by the applicant. Given the findings of fact of this discussion and the applicant's submitted materials, a motion was made to grant a height and rear yard setback variance to replace as closely as possible to the original structure. This was not a suggestion, this was an integral part of the motion. It only became apparent recently that construction is not close to the original structure. A third story is being added, not original to the house and not granted in the variance. City staff has no discretion by law to ignore the part of the variance to replace as closely to the original structure as possible. Prior to the ZBA meeting, the applicant told the mayor he only wanted to rebuild the house as it was. This was also the request he presented to the ZBA. If the applicant had changed his mind and decided he was unhappy with the variance, his only legal recourse was to take the matter to circuit court. Or if he decided he wanted to do something different and add a third story, he had to come back to the ZBA with a new request. No part of the zoning ordinance gives city staff the authority to modify the variance. Furthermore, according to the zoning ordinance, the applicant's variance expired on June 6, 2024. An applicant has 1 year from the board's decision to obtain a building permit and break ground on construction. The applicant did not have a building permit in June of 2024, and the ZBA should have been alerted to the expiration of the variance. The applicant can then come back to the ZBA with a new request. Instead, it appears that city staff granted him a year's extension. There is no provision in the zoning ordinance that allows this. I served on the ZBA for nearly 10 years, and while mistakes happen, I've never witnessed a series of errors like this. What is astounding is that city staff had a completely different take on the variance than the entire ZBA. What I'd like to hear from city staff is something akin to, what can we do better? As it now stands, the city is choosing convenience over doing the right thing. Convenience is an opinion from the new city attorneys that supports the events that occurred and hoping we will all go away after tonight. But the attorneys could just have easily been asked to defend the ZBA variance, and they would have. That would have been the right thing to do. And the right thing to do is to require the applicant to take down the third story. Finally, I hope the ZBA will have some serious questions answered tonight. New policies and procedures need to be implemented to ensure this does not happen again. A couple things come to mind. First, a two-part conditional variance where the applicant is required to come back to the board with architectural drawings for final approval if the applicant does not have them at the time of the initial request. Second, written notification to the board and the applicant as to when a variance expires and what follows. The citizens of the city who have to live with these mistakes deserve that much. Thank you.
Thank you.
Any other public comment at this time?
Is anybody online?
No.
Allison, Pat. Allison's gonna, I asked her to unmute, but it takes a second.
All right, I believe I'm unmuted now.
Yes, you are.
Thank you, thank you. I just want to briefly say that I find it very disturbing that apparently pardon me? I find it very disturbing that apparently the city intends to do nothing about what's going on at 500 Rose. It does appear some mistakes were made. Number one, a one-year extension should not have been granted by city staff. It was unauthorized. Number two, apparently city staff never looked at the drawings that were brought in to make sure that they conformed with what was stated by Mr. Moss to the zoning board of appeals when he got the variance. And I think that the public is entitled to an explanation from city staff or the city attorney to give a public explanation for what, if anything, does the city intend to do about this? And if nothing, why not? That's all I wanted to say at this time.
Okay, thank you.
Looks like that's it.
Okay. At this time, the next thing on our agenda is training. And we have Laura Genovich, city attorney. Now, just before we get started, I wasn't aware of like what the nature of our training would be, but I know that the three of you have already gone through a ZBA training session.
Right.
So I don't know how necessarily how beneficial it's going to be to go through this page by page. It may be more constructive to just be able to ask more specific questions rather than, go through I mean, in case members of the board don't know, this will be my last meeting on the ZBA. So for me, training is kind of irrelevant at this point. But with you guys having recently or fairly recently gone through the training, we may be better served to just sort sort of target our questions about the ZBA, our policies and procedures, and with the goal of improving our approach to cases, how we construct our motions and that sort of thing. How is that okay with you, Laura?
So this is the ZBA's meeting and I'll take my direction for you. What I will say, I guess, two things. One is that, of course, your bylaws provide for periodic training. I think not just when there's new members. The other part of that is that if you do anticipate having, I don't know the experience levels of your members who are absent tonight and if they would benefit from viewing the recording of a training. Or if you have new members who join, the training's been, put together. And so I can certainly present it and you can provide the recording to new members when they join. That's entirely up to you. I am here at your disposal. So I suppose we'll proceed as you wish, Mr. Chair.
Okay. Part of the reason this special meeting was called was because of some of the issues people have had with one of the cases that we ruled on, 500 Rose case, which was mentioned earlier. And I just want to remind the members of the board to be careful not to discuss anything that was privileged in our confidential meeting, but to please feel free to ask questions. I'd prefer that we not get into a situation where we're trying to relitigate the case of 500 Rose. Okay, this is to improve things moving forward and to allow each of us to feel confident that we know and are comfortable with our policies and procedures, and also with our relationship to the city staff as an appointed board. So with that, why don't we, I'd rather not go through this page by page at this time. I know the other members of the board, I believe each of them has been around longer than the three of you and have also done similar training. So for now, let's we have numbers 4 and 5, training and discussion. Let's start. I know that people on the board have prepared questions. So why don't we just start from there? And that may lead us into other things that need further discussion.
Sure.
So with that, I'd open it up to the three of you. I don't have any specific questions myself, but I'd welcome you guys to have any questions, if you have any questions.
Chris, would you object to us framing this discussion at the initial part of this discussion as lessons learned? So that we can actually understand what all the three of us, and certainly you and Lisa, learned from this experience. I'm new, and every meeting I learn something different, and I go back and do more research and more studies. But it seems to me there was a big lesson. There was a couple lessons learned, and I wondered if we craft our we kind of start out framing it that way, and
Mhm.
still we can reframe it so it's positive and it's forward looking.
Yeah, and I think if you have the packet there, kind of in the best practices, which is maybe a little more than halfway through, it's my slide 36. I think that's kind of, if I understand correctly, kind of the area that the ZBA might want to focus on, or what are some best practices? Whether you want to consider that best practices moving forward, best practices, lessons learned, or however you want to phrase it. I certainly, had in mind some of the recent public comments and comments of ZBA members and putting together some of these thoughts.
If I could, just chime in here. I've done, I am new on the board, I've only been on a year, but I have 20 years' experience, with the city, being the mayor, city council person, planning commission, so I know, I've been around a little bit, and the questions I have really have to do with the relationship of the board. Oh, I'm sorry. Did you get any of that?
I could hear you. Yeah.
The relationship of the board to the staff, specific questions. And then a couple others, and interestingly enough, despite my reading this information in my book and Steve Langworthy, the ZBA guiding light or whatever, the questions I have are never addressed in anything that I have read. So they're apparently outside the box of what we are normally taught.
I'm happy to answer those questions. Go for it. Is the question just generally, what is the relationship between staff and the ZBA?
I guess there is a feeling that the staff has information about a request for a variance, right? And then it comes to the ZBA board. And if the board is on the wrong track in terms of not fleshing out conditions or specificities, is the board to expect that the staff will ask us questions to help us resolve those? Or are we single cowboys and we have to figure it out on our own, which seems to be the message that we've gotten?
So I can answer that by talking a little bit about ZBAs, not just the city of Petoskey, but across the state. And, more for the benefit of those maybe listening who I haven't met, maybe in the public. I've been a municipal lawyer for 17 years. I have some clients for whom I attend every single one of their ZBA meetings, and some that I attend as needed. So I've seen a lot of different types of ZBAs. And by that, I mean, there are some where everyone is, experienced and it really spends a lot of time preparing. And there are some ZBAs, and I'm not suggesting this is yours at all, where, people perhaps don't really look at the materials till they come sit at the desk. So there's really a wide range of that. But across all of those, in most cases, I would say staff performs a very similar function. And that is to handle first the administrative end of providing the notice, receiving the application, dealing with any technical deficiencies, missing check for fees, things like that. And then more substantively preparing some sort of staff guidance or memo, like in City of Petoskey, your agenda memo, which outlines often the background, the property, the application, and the standards that the ZBA may wish to consider. And then you'll also be provided with the application itself. In my experience, staff's goal is to kind of equip you with whatever information staff has and can provide. If they see any problems, if there's anything that might not be apparent, to include that in their memo. But certainly, at the end of the day, and I know you understand this as well, it is the ZBA's decision. So I haven't seen where, for example, and I don't think I would expect to see staff interrupt the ZBA from making a decision that staff disagrees with, because it's not staff's decision to make. Again, I haven't attended any of City of Petoskey's ZBA meetings where there's been a matter up, but that's my experience from other communities. And I'm not sure I've really seen where staff was questioning the ZBA necessarily. So I do think by and large, staff is there to help, and I think they do their best to provide the information. I do think you know, the ZBA often will ask questions of staff too. Staff should, you know, will often make a presentation. So I'm not sure there's a black and white answer to the question necessarily. I think it's obviously a sort of partnership, but at the same time, staff can't really come to it with the opinion of, you know, if it sounds like you're going to grant this, I need to stop you so you deny it, you know, and you wouldn't want that from them.
Well, I guess there's a whole legal issue and then there's ethics. And my frustration is that if the staff knows something that the applicant has requested, but that information doesn't get funneled to the ZBA, we're not on equal footing and it's not a partnership. So should the ZBA then request of the staff all the information they have had from the applicant in terms of what they want?
Well, I would think that is what staff is going to be providing, because what you're going to have from the applicant is the application, you know, letters and support and things like that. I think it's very rare that you'd have a situation, and I'm certainly not suggesting this has ever been the case here. I think it would be rare to have a case where staff is intentionally withholding some information from the ZBA. There would be no purpose served by that.
I'd like to, for the record, suggest that this discussion is in no way trying to point a finger at the staff, but this is to understand how these things can happen and how we can improve our communication. In particular, and that's why I wanted to say lessons learned, I was not on the board when they made the decision on the Rose property, there's a big language change in what was in the zoning variance granted by the ZBA and what the zoning permit said. And to me, that should have been a red flag. And in fact, the big change in the language of the permit is what has created this whole problem. We went from an intent, which you said isn't allowable, to gable and a gable height. And that was never, in all the discussions and all the meeting minutes that I read, gable was never a word that was ever used in the discussions and is not recorded in any of the minutes. As a design professional, I think that's a big omission and a big change to go from let's keep the roof the way that it was and we have a turret to allowing a gable to be, and I don't know how we can talk about lessons learned unless we talk about specifics in this particular instance. No drawings, and I love this suggestion that there's a two-part approval process, and I'd like you to speak to that if that is something that the zoning board can ask for. And written notification of the, you know, of timing, I think is an excellent thing to add to our process. But when there is a significant change in what the board, and I know that our staff sits here and is very intelligent and understands what the whole discussion is, and then to write a permit that is so different, where's the red flag in that? Would that be something that the staff should say, I've got an issue with this, I've got a concern with this?
So let me address first, and I appreciate that all of this is in the context of a specific property. And at the same time, our agenda for this meeting is not that property, right? So I want to be mindful that it's a special meeting and it is training. So we're going to focus on training. And all of this falls within that umbrella. The 2 points that were raised in public comment, I think are both great ideas, frankly. And I think they're both things you can do now without really any formal changes. If you're not going to need an architectural plan for every variance that comes before you, right? There's going to be some that you don't need it for. So if a swimming pool is going to be 7 feet rather than 10 feet, something like that, you might not require an architectural design. I'm just throwing that out there as a as a for instance. But you might have other projects where it is appropriate. And frankly, I think a hypothetical project like rebuilding a house might be one where it would be appropriate to see the actual plans. So what you could say either is we're going to postpone a decision on the variance to a date certain until we have those plans. Under Robert's rules, we wouldn't call it tabling it so much as postponing it to a date certain, so that the decision isn't actually made until you have those plans. Or I think you could make it a condition that, for example, within it's approved conditioned on the plans being submitted and they matching, whatever XYZ requirements are that we want them to meet. So I think there are ways to do that, again, in the existing framework without having to change any ordinance or written policy of the ZBA. I think including a reminder on the written decision that the expiration date is 1 year is also a fine idea. I don't have any problem with that. And again, I don't think that requires any formal change to anything. It is what it is. So including another reminder about that, I think is an improvement in process that you could use. In terms of the zoning permit, I think, that may be a broader discussion beyond the ZBA only because the ZBA does not ultimately have a role in the zoning permit itself. So I'm appreciative of the comment. I know there's some general zoning ordinance amendments underway, and it may be part of that discussion as well.
Could you elaborate on what you just said?
Sure. My understanding is that there are many parts of the zoning ordinance that are being looked at. I think, Lisa, correct me if I'm wrong, I think there's a zoning subcommittee of some kind that's looking at all kinds of amendments to the code. So if there are things that we can learn from that are not within the jurisdiction of the ZBA, like a zoning permit, right? ZBA doesn't issue zoning permits, doesn't review them. Doesn't have the jurisdiction to. If there are changes that need to be made to that process, then perhaps that's something we can look at in the context of broader amendments to other parts of the zoning ordinance.
So, Laura, in section 2007 of the zoning ordinance,
Mhm.
no order of the board permitting the erection of a building shall be valid for a period of longer than 1 year unless the building permit for such erection or alteration is obtained with such period and such erection or alteration is started and proceeds to completion in accordance with the terms of the permit. So that's the zoning ordinance as it pertains to the ZBA. I don't read that there is any discretion given to extend that variance in this language.
So I feel like this question gets into topics that were covered in closed session, and respectfully, I would suggest that if the ZBA wants to have further conversation on that issue, we schedule a closed session.
Laura, my question is one regarding information provided to the board by the city staff.
Mhm.
Would you see any problem with the board by way of a policy or standing directive to the city staff to include in the, let's call it the memo or the packet that is provided to us, a copy of all communications by the applicant with any member of the city staff, or let's say discussions or communications between city staff regarding this particular application. Any problem with including that as information for the board?
No, there's no problem with that. Those are all public records. You might get a lot of scheduling type of emails, you know, but yeah, there's not a problem, I don't think, from a legal perspective with doing that, no.
Going back to my question, which I'm not gonna ask, phrase that way. The zoning board, or the planning commission, as you mentioned, is going through, redoing the zoning, book. So it might be appropriate for our board, either as a whole or individually, to talk to the zoning board and clarify section 2007 so that discretion is not an option. That's permissible. The ZBA can't make this change, but the ZBA does have the authority, I think, to recommend or ask that something be looked at. Is that correct?
Yeah, I don't see a problem. I mean, certainly you want to make sure you're complying with the Open Meetings Act in whatever way you do that. But if, for example, you wanted to either have some language that you're going to recommend or just a, you know, idea or principle to say, you know, we, the ZBA, request that the Planning Commission, you know, look at this section as you're doing your amendments. If you made the decision as a ZBA at an open meeting to pass along that communication, there's nothing impermissible about that.
Right. But we can't do it tonight, right?
I'm not sure it's really within the scope of your agenda for this meeting. And you might want to put some, you know, you might want to even, if you have language in mind, you might want to take some time to bring something to a meeting to propose that.
Well, on our agenda is discussion of policies and procedures. It's not just a training session. So I don't know how that's outside the purview of that.
Yeah. I'm not sure there'd be any real consequence of it because, I mean, you are making a decision, but it's a recommendation. It's not a decision that's actually binding on anyone.
Of course.
Yeah.
Laura, I have a question on, there's no pages here, numbers, so basically in the non-use variance section 2004, 2A, ZBA authority variances.
Yep.
The word is used spirit.
Mhm.
The spirit of this zoning ordinance is observed. What is the difference between spirit and intent? And why is spirit allowed, but intent is not?
I did not write your zoning ordinance or the statutory language from which that comes. So in terms of why they're going to be different words, you know, the Zoning Enabling Act even uses different words in talking about use and non-use variances. There was a case we handled at the Michigan Supreme Court in the last couple of years involving the Airport Zoning Act, but very similar, where I had to trace 50 years of case law on variances. And I can tell you the language has kind of been all over the place. So I'm not sure I can give you a very good answer to the question of why those words were chosen, except to say I didn't choose them.
No, I didn't ask to know what the difference is between spirit and intent and why legal it's not.
Yeah, I'm not sure, you know, spirit people use kind of colloquially, and I suspect whoever initially wrote that kind of had that, you know, it's like when people say, you know, the spirit of the law, it's the spirit of the rule, it's, you know, the gist of it, it's the basic idea of it seems to be kind of how, you know, that, but that language, that spirit of the zoning ordinance is observed, public safety secured, and substantial justice done is in the statute. So it's not even a Petoskey thing. I mean, it's reflected there, but that comes from the statute.
So the burden is on, I'm not an attorney, so I'm not going to phrase my question very much. It seems as though intent is the applicant and spirit is what we are following. Is that a implication of that?
I'm not sure that's the distinction. I think in all respects, the applicant always has the burden of proving entitlement to a variance. So I'm not sure there's a good reason why the writers of the statute said spirit in one place and intent in another.
Now, the intent was a part of the variant that was issued, which I was given to understand intent meant nothing.
No, well, okay, so without discussing any specific case necessarily, when this is talking about intent of the ordinance, that's different than talking about intent of an applicant. Those are two different things you're talking about, that the ordinance is talking about, or the motion versus the ordinance. When the ordinance is talking about, is this, not substantially impairing the intent and purpose of the ordinance, for example, in that use variance language, it's talking about what is the overall purpose and intent of our zoning scheme? And is this, compatible with that, not compatible with that? That is, I think, a different use of the word intent than in particular motion language where it recites that the applicant intended something. Those are the same word, but used in different contexts.
Well, would you say based on, and I'm not trying to put you in a corner, I'm trying to understand that we should at no time use intent in our variances?
I would never give you a blanket rule like that. Because you could certainly use intent in a way that makes sense. So no, I don't think that would be the takeaway from any of that.
I mean,
I think the takeaway, and going to, again, some of the slides that I had in here, is using perhaps this discussion and these questions and comments that have come up to say, when we have a variance request, we want to be very specific in deliberating on what is being requested. What are we approving? Are there conditions that we need to put in place to be guardrails to make sure that that what we're approving is what we mean, is what we want to see happen? Do we need more plans? I mean, if you have a specific site plan, let's make this just a really simple, side yard setback variance, something like that. And you have a site plan that shows where that wall is going to be, that's probably enough information because that's the issue you're dealing with. So it's going to always depend on the nature of the case in front of you, what you need. And it's okay to ask for more information. It's okay to not decide at the same meeting as the public hearing, and to ask the applicant to, I have one ZBA client, a township client, that will often say, like, look, the feel of the room here is you're not going to get this, but if you want to modify this and come back, we might be willing to consider, kind of a compromise on it. So kind of having that flexibility with it. But the other thing that sort of struck me when I was going through some of this is that your standard for granting a variance in the actual language of the ordinance is quite narrow. I mean, it talks about in 2004 2A, the ZBA shall consider dimensional variances by reason of exceptional narrowness, shallowness, shape, or area of a specific piece of property at the time of enactment of the ordinance, or by reason of exceptional topographic conditions or other extraordinary or exceptional conditions of such property. The strict application of the regulations enacted would result in peculiar or practical difficulties to the owner of such property. So whenever we're looking at a variance, we've got to ask, what is the exceptional or extraordinary condition of this property based on its topography, narrowness, shape, that justifies a variance? That needs to be the starting place.
it's a narrow box that we're put into. And yet, when you read back through and you go through some of these, and spirit is one of the words, and there's even language in there about, and I've been going back through and reading the book, is the city of Petoskey's intent. And it seems to me that there's we got to stay on this really, really narrow road. And if there's a question that we have that we don't give a 4, we can't check off in all confidence. We can't check all 4 boxes, then we need to be able to say, this has, and I think we've said it in meetings, this has to go back to the planning commission because it doesn't work.
Yeah,
Well,
sometimes you can't grant a variance. And what I was saying, I didn't mean to cut you off. Did I cut you off?
I'm sorry, I feel that we are forced to make that decision sitting in the meeting that night when there should be additional considerations.
So let me say 2 things if I can. One, yes, it talks about spirit of the ordinance, but realize it's what it says in full. And this is from the statute, is that the zoning board of appeals may grant a variance, but it still has to be in accord with the rest of the ordinance. So for yours, yeah, spirit of the ordinance is great, but it still has to also fit within that unique topography, narrowness, size of the parcel. Secondly, staff can't not bring it to you, right? So if they say, yeah, this is probably something where there shouldn't be a variance, there should be a zoning ordinance amendment, but a person applies for a variance, it still has to come to you. They're entitled to have their public hearing and have you vote up or down on their variance. So you might decide, look, this doesn't meet the requirements for a variance, but so we're going to deny it. If you want to go petition for rezoning, if you want to, seek a text amendment and ask the planning commission to initiate that, feel free. Not everything's going to be suited for, a variance. It's kind of like, the example I sometimes use is I personally have a pretty small lot. Okay. And I comply with all the setbacks. But what if my teenager who just turned 16 and got her driver's license on Saturday, true story. What if my husband was like, hey, we need another stall on our garage so we can fit her car in there, right? And then we need a setback variance. Well, there's nothing unique about our parcel or exceptional about its topography that would warrant that setback variance, right? There's no need for it. That's our personal situation. We might want to have another stall in our garage to fit the teenager's car, but that wouldn't fall within the parameters of an appropriate variance under your ordinance. So my remedies then might be, see if I live in a township, see if the township would amend the zoning ordinance to change the setback for my district, right? It would have to be a legislative fix. So if I sought a variance from a ZBA that had your language, the answer should be no, because there's nothing unique about my property that would warrant that specific variance. So I do think you have to start there with these discussions for what that's worth.
Could you maybe spend a little time and talk about, or maybe offer some tips on how to write a good motion?
Yeah, I think that's a great question. So I think your motion, you need to spend a little bit of time working on it in your meeting. Often what'll happen, right? This happens at any kind of meeting. We've all been there where somebody makes a motion and it does not maybe make sense the first way it comes out because, people are just trying to think while they're talking. So taking a moment to kind of maybe even write it out or have either staff write it out, or if I'm attending the meeting, I'll usually try to help, wordsmith it so that you're covering, it's being granted, as requested, which might be the case sometimes, or it's being granted, what specifically is being granted of the request, subject to these conditions. What's separate from that, and I think where things can get messy and how a motion is made, is where you put those findings of fact, because you do need to make findings of fact in support of your decision. And that's, I'll pull up your section here. I can't put figures on it, but you want to have, and I have some examples, some case law examples in the training presentation on, when ZBAs do and do not have good findings of how that can affect the judicial review later. So if you use a decision form. I think that is helpful. To maybe even fill it out before there's a motion and say, okay, so I'm going to put together this proposal to grant it on the basis that, there's exceptional topography, or shape. The parcel's a triangle shape. So of course they need a side yard setback variance because they can't fit a house there, whatever those findings are. And maybe there's a condition that they have to plant 6 trees because of this variance, and put all that in there and kind of get that whole package together and then make one motion and vote on that.
Are there limits to the conditions we can put on a variance?
They have to be reasonable and they have to be related to the property and not the people. So things like buffers, are a common condition. Requiring other approvals or reviews. Sometimes it might be, it's approved subject to fire department reviewing, XYZ. Location of certain items in a site plan, maybe yes, this deck is approved, but, it can only be 1 story instead of 2, whatever the facts might be. It has to be on that parcel. So you can't require them to make improvements to something that's not on their parcel. That doesn't often come up with variances. That usually comes up with special uses, but really there's flexibility there to be creative so long as it's reasonable. It's got to be related to the goals of protecting, the city and the neighboring property owners, and not just arbitrary.
So is it better to demand architectural drawings as a condition? Or is it acceptable to say the height variance is granted for only a portion of the property?
I'd rather see it, whether it's height or anything where if you don't have a visual, then I think your understanding might not align with somebody else's understanding. So in that case, it kind of depends on the timing of the project. If they already have plans, then you should get the plans before you approve it. If they're getting the variance first before the plans are drawn up, then maybe that's where it's a condition that, all right, you've got to bring the plans back.
And the plans would come back to the ZBA, not.
I think you can put that in the condition. You could have it be staff review, or you could have it be ZBA review.
That also could be the 2-part approval.
Yeah, I haven't seen it done specifically where it's a 2-part approval. It's more either it's a conditional approval, so it's approved, but they have to come back because there's a condition. So it's not really approved until that condition is satisfied, or you just postpone the actual approval until you get the designs you need.
When there's a question regarding a requirement, and it's a pretty complicated question, or at least it's not something, the way that it's written doesn't make any sense, or there's some conflicts in the way that it's written. How do we, and it comes up in a request for a variance, if we have additional questions and would like to really understand more how that particular requirement was created, what's the mechanism for that? Is that something outside of a meeting? Is that, how do we ask that question, and how much time do we have to learn more about that?
Yeah. To whom would you be directing that question? To the applicant, or to like city attorney, or what kind of?
It's in my case, specifically, it's a requirement for a square footage. And I'm continually studying this, but in the time when we were requested the variance, it was, this is the way it's written, this is the way you have to approve it or disapprove or not grant it. And so there wasn't, and I understand, I'm just trying to educate myself, but is that something that only goes to the planning commission? And is there a mechanism and allowable for the zoning, people on the zoning board to talk to the planning commission and understand where their position is.
Well, you should have one ZBA member who's on the planning commission, right?
Do we?
Yeah.
No.
You know,
You don't? I think your bylaws provide that you're supposed to, and that's exactly why.
it's not in our bylaws, you know.
Okay, well, it is. One member, one more member of the Board of Appeals may also be a member of the Planning Commission, so not required, but that's why, because often that member can provide for that kind of insight. So it's really hard to go to the Planning Commission and say, why is this the ordinance, right? Because they didn't necessarily write it, the people who are sitting there. You can postpone, again, the ZBA as a whole can postpone a decision if they believe further research, investigation is needed, if they want more time to think about it, they want to drive by the property, they want to ask the city attorney a question, they want the applicant to come back. So I think there's all kinds of grounds on which you can do that. And there's not a strict timeline for coming back. Obviously, you want it to be reasonable. You're not going to keep somebody, coming back every month for months on end. But I think often it will be hard. If your question is just why is this the requirement, the ordinance, I'm not sure how you can get a good answer to that unless you just go back and read the minutes of when the ordinance was adopted.
No.
Okay.
A little bit more.
I think I misunderstood your question then. I'm sorry.
You answered, I think we should have somebody sitting on the planning commission and we should be able to postpone decisions if there needs to be greater understanding or study about what a certain requirement is before we deny an applicant's request for a variance if there seems to be a conflict of spirit.
We've always had the option to not, render a decision at a meeting. That's all, that's not like, we've never been required to rule on something in a given meeting. And I think, at least for as long as I've been on the board, I can't remember, I could be wrong, but I don't remember any cases where we didn't make a ruling right. I think we usually feel like it's sort of obligated to give the person, the decision right there. And maybe that's kind of the wrong mindset for us to have.
And going forward, I think.
It's like, let's get everything we need. And if we're shaky on something.
Well, and I also think that
Don't rule.
the city is in transition. And our guiding principles are changing because we've gone from, and this is a different discussion that's not a part of this, but, there seems to be some zoning rules that were made when, it was a NIMBY. We don't want you there. We don't want this there.
Mhm.
And now that's not exactly the whole spirit of what Petoskey, the city of Petoskey is about. And maybe that's a step that we haven't really, that's not a part of our discussion. We don't get to talk about what is the city and what does the town really want and where are we headed and where are we going. That may not be part of the zoning board of appeals.
Right.
So, but to be able to postpone a decision when somebody has enough questions that they're not comfortable making a decision, I think should be allowable and encouraged because we could be making better decisions, or
Mhm.
could we be making better decisions if we had more time?
Mhm.
And specifically when it's a major decision like the Rose Street property, or like the multifamily housing that we denied because it could meet all the requirements, but not the square footage of the lot size. Those things might need more time.
Mhm.
I think a lot of the decisions we made were very clear.
Mhm.
One thing I wonder, John. So I was looking at the ordinance revisions that are on the website in the city of Petoskey. And when I was checking out the ZBA changes, I think I read, correct me if I'm wrong, that part of the thing is decisions should be made promptly. The word promptly was in there. So promptly, what does promptly mean if we're now talking about delaying or postponing to another meeting? Does that conflict with the language that's being discussed?
I think it gets to Laura's comment where she said that the ZBA doesn't want to get into a position where they keep having the applicant come back month after month after month after month.
Mhm.
And, you know, the terminology promptly would be that it's got to be a reasonable time frame.
Okay,
You know, I mean, if the ZBA has a request for additional information, then as Laura has mentioned, the ZBA has the ability to postpone and request staff or the applicant to bring back additional information. But I've seen it before where a ZBA didn't really want to make a hard decision, so they kept asking the applicant to come back every meeting with something else. And it got to a point where the ZBA had to, at some point, the ZBA has to make a decision.
so it was here or elsewhere?
It was elsewhere, not here. But I think it gets to what Laura was saying is that the request from the ZBA, if they're seeking additional information, should be within a reasonable.
Oh, I agree. I just wondered if it conflicted. Promptly seems,
I think
multiple interpretations.
we could take a look at the word promptly, maybe replace it with reasonable, but it's got to be within a reasonable timeframe.
I understand that.
And while we're talking about it, is if the ZBA has any specific concerns relative to that portion of the ordinance.
That we're not allowed to speak about.
Well, no.
No, that wasn't what I intended to communicate. Go ahead.
Issues that the zoning committee is reviewing those articles.
Yes,
So if there's any recommendations you have, please send them forward so they can take a look at them.
okay.
Because they're open to that. That's what
Right.
they're doing right now.
Well, and I guess one thing, I mean, not to belabor this, but from the ZBA's point, we grant a variance or not, we ask questions or not, and then there's the administrative arm of the process. And unless things are very clear, we don't really know what the administrative decisions are. And those decisions may or may not affect the larger process. So I don't know how we resolve some of those issues. And that section I mentioned might be looked at. But it is a question, you know, because if some things happen administratively and they're not in the public view, it changes an outcome.
Laura, if I may.
Mhm.
If the ZBA, just like the planning commission does, if the ZBA attach conditions to its approval,
Mhm.
Yes.
those conditions would be met and addressed by the staff as part of the implementation of that application. Just like the planning commission will attach to a special land use, maybe they'll attach a number of conditions.
Right.
When those plans come in, it's between myself and Lisa as the zoning administrator to ensure that each of the conditions that the planning commission requested are in effect met before any other actions taken by the city administration for a zoning permit.
Yeah, I think that's correct, unless there were some explicit language in a condition that required the ZBA to review something else, then it would go to staff. And as a practical matter, that makes sense, right? I mean, if a condition is plant 6 trees, you know, the applicant doesn't necessarily need to come show the ZBA a picture of 6 trees, you know, Lisa or John can go count the trees. So.
Well, in the case of a year's time limit on a variance, that doesn't always come forward. We don't always know what happens.
Yeah, I'm aware of the issue that you're talking about.
Right, talking around, right. So there's language that could be changed in a mysterious ordinance.
I think there's a few things, frankly, in the ZBA part of the zoning ordinance that could use some wordsmithing, so I'm sure. And one of the things, frankly, about that is that language you're talking about with 1 year doesn't even actually say variance. It refers to the building. So there's, you know, there's a few things I think could be improved and in the language of the zoning ordinance. And that's why we're allowed to amend zoning ordinances so that, you know, we can continually improve them. There's some outdated references to previous zoning laws, you know, so there will be some things to clean up in this part of the zoning ordinance. And I think those will also aid in improving the overall process.
Also, another confusion I have is that because the zoning permit is issued by the city, but the county issues the building permit, right?
Correct.
So, I mean, one can call the county and say, what's up, but, you know, the ZBA doesn't always know if a building permit has been pulled or not.
Well, and the ZBA, I mean, to be fair, the ZBA doesn't have enforcement authority either. So if somebody doesn't get a building permit, that's an issue for the city, you know, and or the county to deal with, but it's not going to be the ZBA that has to deal with it.
Unless they have to come back to the ZBA. If a variance has expired, they have to come back to the ZBA.
If there's a new variance application, then that'll be treated on its own merits. But I guess my point was, the ZBA isn't going to get notification every time a building permit is issued when a variance, you know, has been approved either, just because there would be nothing, there's no action for the ZBA to take on that.
I'm speaking of specifically when a variance has expired. That's.
I appreciate the issue you're raising.
Lauren,
Turn your mic on.
So. Shine your light on.
pardon?
Shine your light.
Would you see any problem if the board chose to incorporate into the motion with conditions, incorporate and thereby require compliance or with schematics, photos that are presented to us by the applicant who says, this is what I'm going to build.
Mhm.
We could attach that to our motion, could we not?
Yeah, you could absolutely incorporate it. Yep.
Shall be
Mhm.
part of, and that's what we're approving.
Yep. Yes, you can do that.
And now that's all.
But referencing it is not enough. You have to actually have it there.
Well, you can't really attach something to a motion because motion's out loud, but you can, you know, as depicted in the site plan dated July 1st, 2025, prepared by X and Y engineers, you know, you can describe it sufficiently as attached to the application, something like that.
So we could physically attach to the motion,
The decision form,
the schematics, the photos with the verbiage about this variance is requested, and we'll go through all of it consistent with what the applicant has presented to us, the schematic, the photos, which are attached and incorporated into this variance.
Yes, you can do that.
Another thing I wanted to ask about, regards motions, because I mean, the motion is like the whole thing, but I mean, that's whatever the motion is what's gonna happen, so it's like critical. In the past, or since I've been on the board, the way it's always worked is we'll have our discussion, the public comment, we'll go through our checklist, and then somebody will just sort of take it upon themselves to start writing out a motion. And my question is, can the motion-making process be collaborative, or does it have to be all come from a single person? I know it has to be, but can be like crafted as a group? Is that?
Yeah, there's no problem with that. Ultimately, one person's going to make the motion. But especially if you're going to take the approach where you're going to say, okay, I've got this decision form that has a spot for what we're approving, what the conditions are, what the findings of fact are. I'm going to kind of maybe you could say collaboratively of anyone who agrees with you, fill that out and then, read it and then say, my motion is to, approve the variance with these conditions and with these findings of fact. And then that can be seconded and voted on. But like I said, when I attend ZBA meetings, I often help with the motion language right there on the spot. Not because I want it to go one way or the other, but because I want the motion to be clear. And I'm obviously, as the attorney, I'm still not the one making the motion, right? My point is, as the attorney, I can help craft that when needed.
Does anyone else have anything they'd like to ask or discuss regarding our policies and procedures?
It seems to me that one of the things that at least I'm wrestling with, and maybe we're all wrestling, is the scale of these decisions that we make. So many of the ones that come in front of us are very simple and clear. But when they start getting into a larger discussion or a larger decision, that's when we need to be able to say, this checklist is a good guideline, but it's not the entire discussion. I mean, does that make any? When there's no drawings and someone's building a new building, that should be that to me is when you start requiring as a condition a set of plans.
I mean,
If it's a new building, it should require a set of plans.
after, at this point, I would never, approve. I mean, with the understanding that there, like Laura said, there are certain things you just don't need a drawing for, but like anyone who was like wanting a height variance or a, lot coverage variance, I would not feel comfortable approving anything without seeing architectural or engineered drawings.
I totally agree.
And hopefully, as my sort of final departing whatever for the board would be to sort of keep that as sort of a, whether it's a policy or just an understanding that, hey, if you're going to come before us and you don't have any drawings to show us, get some drawings first. And then we'll talk.
Even to this extent, when there was one that we recently passed and it required an engineering, or it was a construction of raising the whole building. That was all we heard. I'm going to raise the building 2 feet. There was no, so.
It wasn't variance, though. There was no, it wasn't.
Yes, it was. We issued a variance
I know,
to
but it
raise the
wasn't
building 2 feet.
No.
Wow.
We did not?
The variance was because the house was being moved, and for non-conforming structures, it states that movement in any direction for any distance requires conformity.
Which was raising the house.
But it wasn't for the height. There was no variance for height. That was within the allowance of the ordinance.
Yeah.
It was simply allowing him to lift the house so he could repair the foundation or replace the foundation.
And were we very specific? I think that was one you wrote, and it was really specific, but I just want to make sure that even if it's a situation that's involving a means and method of construction that could change how.
See, like in a case like that person,
He was,
I'm guessing, didn't get architectural drawings
he's the contractor.
of, because the house he's not changing anything about the house other than raising it. So, like
Other than raising it, so why get an architect? Or involved?
you have necessarily like elevations drawn of the house because there would be no architectural reason for it to draw if all you're doing is building a new foundation for something, you wouldn't need that.
Every of these cases are gonna be so unique
And
to themselves. And one of many lessons is our need to do our due diligence when somebody comes, and it's not something as simple as you gotta raise it 2 feet, replace the foundation, set it back down. Anything, each one is going to be what level of additional information is it necessary for us to have in order to determine whether meets the criteria for a variance, whether this applicant is going to build it exactly as we approve or he requests. And so getting what he requests and what we approve, we clearly those are going to be going forward. Then will need to be identical. And there are suggested ways of trying to assure that what we approve is actually what we're going to see on the ground in 6 months or a year. That is just fundamental. And that's why I asked about attaching schematics, attaching photos to a variance that we do approve, so that the applicant isn't able to thereafter, for example, say, the wording, although it didn't match what I told you in the schematics and the photos, the wording is different. We will never be in that position again.
The other thing, and I agree with that, comment that you could attach those, and then that makes it very clear. The other thing I've done in some unique cases, not as a matter of course, but where there's either, a significant project or one where perhaps there's a lot of opposition and, there's perhaps a likelihood of an appeal, is actually my office drafting, drafting a resolution, which is like a written formal motion with the attachments. So it's all one package that's like, these are the findings of fact, these are the documents on which we rely. Exhibit A is the, schematic plans that submitted, the variance is approved, specifically as to this. And so there's one whole package that the ZBA can then vote on. Again, you don't need that for every variance, but if you've got one that is remarkable, that's another way you can make sure it's very carefully documented.
I have one question. if the board does choose to say, you know, it's approved on a condition of the architectural drawings, is there any time limit to that? Like, can the architectural drawings come in a year later, or is it reasonable to say within the next 3 months and then we will revisit, or what is the proper way of looking at that?
Yeah, we'd want to put some kind of time frame on it, either, you know, indicate that, look, your variance is good for 1 year, so you have that time, or it's, you know, you've got to get us these in 3 months so that you still have time to, you know, go with your other approvals. You really, because some people, I think it makes sense to get that variance first so that they don't spend thousands of dollars on plans that they'll never be able to build if they don't have a variance. So I understand some of that reasoning. I think you could still have conceptual plans at the application phase that provide some detail. But regardless, again, I think the common theme here is it's going to be very much a case by case basis. And in some cases, you might want to put a timeline on it that's different than in other cases. But you do have the authority to impose those conditions, you know, to postpone making a decision. And yes, you want to act with reasonable diligence. To John's point, you don't want to just not make a decision because you don't want to make a decision. And I don't think anyone here is saying that's what they want to do. But making sure you have the documents and the information that you need to make a decision is well within your authority.
Thank you.
I've got a procedural question for you.
Mhm.
ZBA is confronted with a complex decision because they are required to hold a public hearing, and they want to postpone that decision to give the applicant more time.
Mhm.
In your opinion, can they also postpone the public hearing in terms of keeping it open so they don't have to renotice?
So you only have to have a public hearing once. So if you have the meeting, you have the public hearing, you can close the public hearing and still make a decision at a different meeting.
Okay,
They won't have to have another public hearing.
because that's a question that comes up sometimes. Do they have to renotice? And
No, unless you don't hold the public hearing. So if, you know, which I wouldn't recommend, right? Have the public hearing, have them present what they have. Now, if the applicant then changes their plans completely, you might need another public hearing then, right? If they come and read the room and realize they're not going to get the variance they asked for and they're going to dramatically change their plans, again, case by case basis, we might need to re-notify neighbors if the plans are going to substantially change.
Does anyone have anything else they'd like to,
I'm done.
done?
No, I think we covered a lot.
I think for me, the biggest sort of takeaways are having architectural drawings, not feeling obligated at any meeting to make a ruling if we're not 100% clear or we don't have all the information. And to be almost like excessively detailed and specific in our motions and our conditions. I think we probably don't use the conditions part of our motions as much as we should. So.
And I would add to that, that discussion is encouraged.
Oh, yeah.
You mean in the making of a motion or like
As we go through this, that we encourage discussion amongst ourselves and with staff, so that everybody has a chance to really ask their questions. And maybe there's a question that comes from asking a question, so that it's just slow down. We just need to slow down, because we don't want to hurt the city or the residents of the city in any of our decisions, just because we feel like we need to make the decision. But I agree with everything you said.
I think oh, I was live already. I don't know that we do it, but we need to show fidelity to the underlying zoning ordinances. The variances that are sought are the exception to the spirit of what we're trying to do citywide in the building.
Right.
And we shouldn't have any feel any pressure to, God, well, I help the guy almost.
Right.
So strict fidelity to the criteria, it's just necessary to support the ordinances in general and do our job properly.
It shouldn't be easy to get a variance,
That's right.
you know?
Right.
Always kind of been
Right.
my attitude. Okay, if no one has anything else to add, we could move to adjourn. But,
So moved.
okay, second, all right.
Thank you very much, Laura.
Yeah, thank you. I think that was a productive use of time. Thanks for having me on.
Have a great evening. Thank you.
Take care. Bye-bye.